because I've heard the Senate ask a very curious question. But there's a headline on page 8 of the Daily Nation. Speaker Justin Muturi asks, wants to scrap High Court powers on laws. The National Assembly Speaker wants powers of interpreting laws transferred from the High Court to the Supreme Court. He has called for a constitutional amendment to bar High Court judges from overturning deliberations by the Senate, county and National Assemblies to avoid conflict among the various arms of government. But don't you think this in itself is a conflict? The right or the role of interpreting the laws is vested in the judiciary. Why would the head of another arm of government say the judiciary should not do this, they should... do you understand him?
So probably I think, let me try to think for him, because it can only be speculative and think outside the box in a way. Because what the speaker is suggesting, if I've got a new right, is that it doesn't say, or is not suggesting that the power to interpret the law should not be with the judiciary. Because according to our constitutional architecture, the role of interpretation is squarely on the judiciary. The judiciary is the Chief Magistrate Court, the High Court, is the Supreme Court, is the Court of Appeal. But I think when he was, what he is trying to suggest here is that the High Court, you know, according, I don't know whether it's Article 165, the judicial authority is vested in the courts. And what Muturi is saying is that because the High Court has unlimited jurisdiction, unlimited powers and authority, that court sits and decides on a law that has gone through various processes before or even after assent, because you can never take it unless it is assented to. So Muturi is saying, look at this process. Parliament is involved, the public is involved because the public is there, and after the parliament or the houses of parliament are satisfied that the law is good for the country and with the involvement of the public, the same is taken to the president for signature. Then the president, as the end of executive, signs or assents to that law. And then that becomes the law of the country. Now Muturi is saying, probably, when you look at all that process, and then if somebody has a problem with that particular law, and considering the stature of the three arms of government, where the judiciary is headed by the Chief Justice, where Parliament is headed by the speakers, and where the executive is headed by the president. The speaker, the two ends of the two arms of government, have an active role in the passage of the law. So I think what Muturi is trying to say is that if this law has to be found unconstitutional or not to comply with the requirements of the Constitution, then other than one single judge of the High Court seated to listen to the arguments before him by various parties and then make a declaration that that order or that law is unconstitutional and should be of no effect, then it's unfair because it's one single member bench, considering the other processes that have taken place to have the law in place. So I think he's suggesting saying that the law to interpret, the power to interpret the laws should now be moved from the High Court to the Supreme Court, where the hand of the judiciary is seated, who is now almost at the same level with the speakers and the president, and sits at the president of the judiciary, together with the other Supreme Court judges, who are around 7, and then make a determination, because we expect more justice from 7 minds looking into a law than one single judge.
And of course, Justin Muturi is no stranger to the law. He is a lawyer, an advocate to the High Court as well. Do you understand his argument?
I do. I know where he's coming from, only that we have to look at the architecture of the Constitution and what the people intended when they created the hierarchy of courts and made the Supreme Court the apex court. We need to look at what was the intention, and looking at Article 1, I think it is 163 of the Constitution. It says that the Supreme Court has jurisdiction divided into three. Original jurisdiction to determine presidential election. So what really that says that the main business of the Supreme Court is to sit to determine one question relating to presidential elections. Secondly, it has jurisdiction to deal with appeals. So that is an appellate jurisdiction. And this is appeal from the Court of Appeal. And then it goes on to define what that appeal is. It is automatic when it is a question relating to interpretation of the Constitution. So the Supreme Court already interprets the Constitution, but as an appeal on matters involving the Constitution when it comes from the Court of Appeal.
Okay.
And then it has an advisory jurisdiction, and it has advisory when one arm of government decides they want a question to be determined, like the gender question. A constitutional commission can take it there. The Land Commission has taken issues there. So it is important that we look at in the hierarchy of courts, what was the intention, so that when you take away the exclusive jurisdiction of the High Court to determine general questions of interpretation, you will be upsetting the architecture of how the Supreme Court was crafted. Look at the magnitude and the number of things that go before the High Court ordinarily. The apex court then ceases to be apex and becomes an ordinary court where every other single day somebody is not properly appointed, we will be running to the Supreme Court. Somebody does something to do this, we will be running to the Supreme Court. That was never the intention, but I see the Muturi's issue to be that the High Court has appeared, or the judiciary has appeared at times to stifle the role of Parliament in terms of legislation. If that's what the problem is, I would agree with him, but only to the extent that Parliament should not injunct processes of lawmaking before they are concluded.
Because there is a process.
There is a process, and that's what is referred to.
And eventually to the Supreme Court.
Yes, there is a process. And also the process that it talks about, that the process begins with committee work, and then it comes to first reading, second reading, third reading. In between, there is a lot of public participation. A lot of overzealous people have run to court, and I know sometimes when I was doing public interest litigation, we tried to do this. It depends on which side you are at any given time. But the proper reading of the law and the jurisprudence that now has been developed is that so long as a process of lawmaking has not been concluded, the court should not be quick to intervene. If that's what Muturi was trying to do, I agree with him entirely. But if he's trying to say, let's change the architecture so that only the Supreme Court, and remember, and this is very crucial, you'll correct me if I'm wrong, Senator. You know, it says at Article 2 that the role of interpretation of the Constitution is done by almost everybody, isn't it? Even government itself does interpretation. The only thing it says that whenever any arm of government or organ of government interprets the Constitution, they must take into account the following. Anybody can interpret the Constitution, but in terms of making a determination of constitutionality, a pronouncement, it is the preserve of the High Court. And then it escalates on appeal to the Court of Appeal. Then the Supreme Court has appellate jurisdiction when it is coming from the Court of Appeal, exclusively when it is a question of constitutionality. So I think we shouldn't disturb the architecture of the Constitution the way we are. Otherwise, we will make our Supreme Court another ordinary court. And I've been one person who's occupied the opinion that even in terms of election petitions, the Supreme Court expanded its jurisdiction beyond what I think was initially intended.
It should not be handling some of the issues it's handling.
Presidential petition, that's it.
Yes.
And then the Supreme Court has assumed jurisdiction to the extent that dispute of an MCA position can go there. Matters that should go to the Supreme Court is if along the apex, the hierarchy of courts, there's something that is so novel that neither of the chains from the High Court to the Court of Appeal could not determine.
Okay.
A constitutional moment has arisen. So let's take this MCA election petition or MP position or Senate position, then the Supreme Court can pronounce itself. Okay. So I think the Supreme Court itself has also expanded its jurisdiction beyond what was contemplated in the Constitution.
According to this story, Mr. Muturi wants Article 165 of the Constitution, which gives the High Court powers to interpret laws, scrapped.